It might seem scary being charged with drug supply, but it's important to know that there are ways to get drug supply charges dropped early on, so you don't end up having to go before a magistrate for a defendant hearing in the local court, or before a jury in the district court. The first thing for you and your lawyer to consider is whether you should have been charged with supply at all. As mentioned in some of our other videos, drug supply does not include cases where you've given drugs to someone else to hold on to temporarily if they intend to give them back to you, or where you're holding on to drugs for someone else and you intend to return them. It also does not include situations where you've asked a friend or another person to buy drugs for you. Equally, the prosecution may not be able to use their evidence against you in cases where your car or your home was searched illegally. For more information, check out our video on illegal searches. In all these cases, your lawyer should write to the prosecution asking for the charges to be withdrawn or downgraded to a charge of drug possession, which is a lot less serious and has more lenient penalties. In cases where you've been charged with deemed supply, your lawyer may be able to advise the prosecution that you did not intend to supply the drugs and request that the charge be downgraded to possession only. A good drug lawyer will often also be able to persuade the prosecution that there is insufficient evidence of supply in deemed supply cases. They may, for example, point out that there is an absence of multiple mobile phones, large sums of money, multiple resealable bags, scales, etc., and that the drugs in your possession were for personal use only or held for another person. They may also be able to point out that the prosecution cannot prove that you possess the drugs exclusive of all other persons. In fact, it may be difficult for the prosecution to prove exclusive possession in deemed supply cases if the drugs were found in a common area of a shared house, such as the kitchen, lounge or bathroom, or in the boot of a car that you were driving, especially if the car didn't belong to you. This is because there's the possibility that the drugs belong to someone else. Drug charges may also be dropped where there is insufficient evidence to prove that you possess the drugs in the first place. This may include situations where police claim that they saw you dispose of drugs when it's possible that someone else may have put them there. So there are many ways that a specialist drug lawyer might be able to fight to have your drug supply case dropped or downgraded, or thrown out of court if the case goes to a defendant hearing or jury trial. Remember, your best chance at fighting and beating a drug case is to get a specialist drug lawyer on your side. Here at Sydney Drug Lawyers, our specialist lawyers have a high success rate of getting charges dropped for our clients at an early stage, sparing the time, expense and stress of a jury trial or a defendant hearing. Where cases go to hearing or trial, we have a success rate that is second to none when it comes to winning cases in court. Our experienced lawyers appear in court on a daily basis and are highly respected by magistrates and judges, especially when it comes to drug cases. So trust the experts and give us a call today to find out how we may be able to help you beat your drug charge.